May it please the court. My name is Veronica. I am from New South Wales and I appear on behalf of the Defence for the Trial DPP and Douglas. The defence seeks to exclude the witness statement of Miriam Starr on the basis that the evidence is inaccurate and tainted. In furtherance to the defence written submissions 26 June 2021, the defence submits that the evidence should be excluded on the basis of the inability to meet the requirements of Section 55 of the Evidence Act 2011, relevant evidence, and Section 56 of the Act, relevant evidence to be admissible. The following submissions from the defence will depict a clear understanding as to why the statement does not meet the requirements. In the alternative, the evidence should be excluded on the basis of my friend relying on Section 79(1) of the Act, exception, opinions based on specialised knowledge, supported by lines 3 and 4 of the statement. Regardless of Miriam's prior knowledge, her evaluation of the shotgun may very well have been coerced. It would not be fair to allow this evidence into court based on the balance of probabilities. The evidence should be limited in use, if not excluded altogether, as my friend may attempt to apply necessity and reasonableness to Miriam's witness statement by making an example out of her qualifications and experience, regardless of whether or not she has examined this exact shotgun before. My friend may make many attempts to suggest the relevance of this evidence, as without this piece of evidence, my friend may be unable to suggest that the shotgun could have been fired without difficulty or by accident. The defence would like to reiterate that the deliberate opinion asserted by the detective to Miriam is the leading objective for the inadmissibility of the statement. The defence suggests that although there is no requirement for Miriam to have specifically examined this exact shotgun before, all that is required of Miriam is the necessary knowledge, skill, experience, training, and education that can be certified by someone as per Section 1771B of the Act. Miriam still cannot evaluate this shotgun to her most truthful capabilities, as the detective asserted his opinion before the examination was conducted. So, her experience and knowledge in this instance does not matter. In relation to the defence's first submission, the evidence should be excluded because although Miriam may legally meet the requirement to be an expert witness and provide specialised knowledge, the reasoning behind the inadmissibility of the evidence outweighs her capabilities and experience. The defence suggests disregarding the entirety of the statement or all lines that relate to Miriam's examination of the shotgun, as it becomes irrelevant after the fact that the detective asserted his deliberate and reckless opinion. Noting the experience and training provided in the police force, it would be appropriate to say that the detective would have known better than to assert his opinion to a ballistics expert before conducting an examination. Due to this, it would be reasonable to assume that the detective knew what he was doing. Whether the opinion the detective shared was accurate or not, it is not up to him to determine the person who fired the shotgun. That is what the ballistics expert and the trial is for. Therefore, it would be fair to say the detective's opinion has tainted the accuracy and reliability of Miriam's examination provided in the statement. Section 101A of the Act supports the defence's submissions of Miriam's inability to be a credible witness for the trial, similar to an issue with the evidence and witness credibility in the case of Dupas and the Queen. Her trustworthiness is on the balance of probabilities, and therefore her statement should not be included. It would disrupt the court's intention to hold a fair trial. Whilst the defence recognises that the detective may not have asserted his opinion to Miriam in a means to hurt the outcome of Miriam's examination, there is also no way to prove it was not his intention. Because of this uncertainty, the evidence has been tainted, and tainted evidence is not admissible. Every trial needs to be impartial and provide appropriate and pure evidence in order for the correct conviction to be given to the alleged criminal. Including tainted evidence in trials would result in the incorrect convictions being served, and that is not what the justice system is about. Throughout the defence's submission, a clear and consistent demonstration as to why the evidence should be inadmissible has been provided. The deliberate and reckless opinion of the detective before the examination was made, similar to the inadmissibility of an individual's opinion that was used to attempt to prove a fact in the case South Sydney Junior Rugby Leagues Club and Goya. the irrelevance of Miriam's experience to the examination when the examination could be tainted. The defense does not believe that David Douglas should be convicted based on the balance of probability as to whether the statement is honest evidence. If he is to be convicted of murdering Barry Clemson, it should be done with pure and necessary evidence obtained legally. The defense humbly submits that for the explanation provided in these submissions, this honourable court authorised the Crown to not present this evidence as supported by the Evidence Act 2011.